we always according to what is always taught. In family, we teach what we call relations. So when it comes to family relations, everything in family rotates around relations. So that's why it's called a relation course unit. Okay, so that being the case, the way these relationships move, the way your workshops are always made. In the first term, you had creation of relationships. That was marriage, okay? Creation. Then after creation, you had what we call results of a relationship. That was children, okay? Now, since you're not God, okay, you will die. But when you die, you already have people that you've been taking care of. That's why we have succession. But you can't be a successor of someone when you are not related to that person. The relationship is either by blood or by law. So we see everything first trace the relationship. Once you get the relationship, everything will be perfect. Okay, so this week deals with what we call succession. The question is, where does succession emanate from? Okay, what are the rights of children? Answer. Among the rights of children, we have a right that brings succession. Which right is that? Yes? But that one also, yes, that, but we have what we call a right to be maintained. Okay? When you look at the right to be maintained, that is the right, what we call the ultimate right. That right does not cease. Okay? Because of that right, whether you are dead, whether you are lost, whether you are unsound mind, we don't care. That right will always be there. Okay? So, because of the right to maintain your children and the people around you, okay? When you die, your estate survives you. It has to maintain the people you've left behind. When you run mad, your estate will not run mad. It has to maintain the people behind you. When you get lost, nofunayo kahajat number bidi, okay, nojjako amasimu, estate eba tejjeko masimu. Okay, we shall go for that estate. It maintains hajat number 1 and her family until you resurrect. Okay, so by virtue of that, you have to appreciate that the right to maintenance does not cease. Okay, so as a result of that, because you know these accurate things, whether I like it or not, it's the reality. We have to face it. Okay, the reason why we are all here at the back course to obtain property. Okay, of course, but 90% of us, the property we want to obtain, it's not ours. Okay, when you ask Hajat or Somera, obwana wange, okay, you see, when you ask Daniel, why are you here? You have businesses out there that bring money. He'll say yes, but my children. Why? You are gathering everything in the name of my children. Okay, so as a result of that, you've gathered whatever you've gathered, but how are you going to maintain whatever you have gathered? You know what is absurd? You wake up, you make plans, okay, for 2 years to come, not knowing that on your calendar you have 2 days. You have 2 days, okay, to die. That's what I mean. 2 days to die. But you woke up in the morning, you made plans of 2 years. What does that mean? We do not have guarantee of staying tomorrow. Okay? But when you read the hadith of the Prophet, sallallahu alaihi wasallam, he said, they asked him, O you Muhammad, what is that thing that one should do on a daily basis? He replied, use the power of your right or left hand. Why? That every day before you sleep, write something either you achieved or you are intending to achieve. What does that mean? In Islam, every day that closes, you should make a will. Because you don't know, you're not certain whether tomorrow will be there or not. That's why we have the morning prayer called Subud. That you've woken up, it's a blessing. You say, thank you, God. Then during the course of the day, because you're not certain, I've reached lunchtime. Let me guys thank Allah. Even in the evening, let me first thank Allah. Okay? Even when you're going to sleep, because you're not sure of tomorrow, before you go to bed, you pray. And so that you talk to God, and then He forgives your sins you've committed previously. So by the time you die, you are pure. That's why you have the 5 daily prayers. Why? You are not certain. Okay? So as a result of that, you've been working so hard to provide for your children. But when you leave, how are they going to be maintained? So this explains why we have what we call succession. So this week, you are going to deal with succession. So ask yourself, what is succession, the different types of succession, and how do we deal with everything? Okay? So now, this is the simplest workshop, okay? Where we're not going to read too many laws, but this requires understanding more than reading the law. That's the challenge, okay? So succession, this is the process through which, no, just this general understanding, okay? We shall read a few provisions of the act and get to the workshop, okay? Succession, this is the process through which property and responsibility of the deceased develops into his or her legal representative. Okay, 2 things, property and responsibility. But this person, that he has the legal right, but is just a custodian of the beneficiaries. Okay, so succession is in 2 ways. We have what we call tested and intestate. Okay, what do you understand by tested succession? Okay, tested succession is where you die with a testamentary, what we call a will. Okay, so now you ask yourself, what are the different types of wills? We have what we call the ordinary will, and then a privileged will. So all of us here, where do we fall? Ordinary will. But regardless of the type of the will, they are all wills. Okay? So first ask yourself, what are the characteristics of a valid will? Whether it is the ordinary will, or what things you look at and say, okay, this is a will. Okay? 1, it should be ambulatory in nature. What's the meaning of the word ambulatory, Aisha? You did literature or Uganda. Okay? Council Daniel, what's the meaning of the word ambulatory in nature? Okay? It takes effect upon death. There is no will that doesn't take effect upon death. Huh? We have a colleague, Yarwal. I know one way. I swear and again the water. I can never infer. Nagambo Micha. That nange. But Nasobia. Okay? Nice our quality. Unsoniwa. Namusa. Ate mkwano chichi. Namnai. Nino mwana. Yeah. Anga nina omwana omukyala n'asooka afulumamu n'adda. Wallahi omukulu teyafa. Teyafa. Amaze okwogera alina ki? Omwana n'ayogera gye yamusaala n'amulina. Ng'amulina mukwano gwa mukyala ate. Omukulu teyafa. Gwe teeberezaamu. Owonye. Listen. You okay? You didn't die. Okay? You didn't die. And Aisha is there. You told her how you have a baby somewhere. Okay? These ladies, you start eating on a sauce plate. For still you lose your life. Okay? So, why? The reason why that may not amount, because it had to take effect when you, but did you die? Okay? So you did. So under such circumstances, what the first characteristics that a will takes effect upon death. Okay? Then the second characteristic, canons of a valid will. Yes? It should be witnessed on each and every page. On each and every page. Okay? Then after it being witnessed, it has to be, the testator has to, how? In Latin character. Okay? Then it should include all properties of the deceased. All. Okay? Then another one, it should include all beneficiaries of the deceased. Okay? All. The Kayoku, you see the problem that children can calculate and they can cause problems. Okay? So, now what happens, you go in Oros, they give you a copy of a will. When it is lacking only one thing of all those mentioned, they tell you the families before you kindly advise. You look at the will, you don't put into consideration that it's supposed to be signed on each and every. When you look at it, you think that the will is valid. Okay? So yeah, it is okay. Let's go for probate. Okay. So what you should note, where a will is missing any of those canons, the will becomes invalid. So it becomes invalid. But remember, the law is very clear. The reason why we have a will, because we have cases, Sitnasanga, which says a will is a document. But that document, it shows, okay, have other cases say that a will is a document that shows the intentions of the testator. So the intention of the testator was to distribute this estate. So we cannot at any time put his or her interest aside, regardless of the fact that the principles of equity prevail. Okay? You made a will, but you left Jeff out. But it doesn't change the fact that Jeff is your son and he has an interest in your estate. You have reasons, but equity has to prevail. So how are we supposed to put two things at the same page? We have to balance the both. So the remedy we shall go for letters of administration annexed with a will. Why do we annex the will? So that when the judge is looking at your petition, should also put the interest of the testator at the forefront. Okay, that's the essence. Okay, so if it is not that ordinary will, okay, that ordinary will, it will be a privileged will. The biggest matter of determination, who can make a privileged will? Listen, let me see. No one is here. Listen, can you make a privileged will? Yes?
Listen to you.
Yes.
Listen to you.
So what we need to determine what amounts a privileged will. This is a will that is made by Marina at sea at what? Okay. So now the question is what amounts to warfare? Okay, because in an expedition of the war, once I receive instructions to go in Amurutaro, yes, I'm a soldier. I've received instructions. But I know that the war is starting next month, but I'm here with you. Can I make a privileged will? So the question we need to ask ourselves, what amounts of the law is active war? Okay? Because at that time, olaba omusajja akuvuga kaboda, olaba akuyingiza trailer sira ndeka wano. Okay? Ndeka wano. Ekikulu hajja kimutya nnyo. Nina abaana. Okay, Ninava. Why? You now imagine, cancel you are to war. Okay, or the Ukraine. Mark 2 and above.
Where you station?
Okay, no, the will, the ordinary will, 2 and above. But the current law requires that every witness has to appear for identification. You bring a death certificate as well. Oh, getting letters of administration nowadays. It's hard. Buli bwe bwalinga ogulimu omuntu bw'ayinza okukolako nga yakava ku LDC. Naye kati bw'abasimya kanso. It's hard. It's a hard process now. Okay, so when you look at all that, okay, succession is the simplest thing, the simplest. Because when now okay, why? Because of succession. Okay, so succession is very simple. All you need to know that now, once you've seen it, when you have a will, whatever will is there, okay, you go for what? Probate. When this person dies without a will, differentiate between valid will and a will. Where you die with a will but it is not valid, you go for letters of administration annexed with a will. But where you die without a will, you go for plain letters of administration. Okay? Okay? Where they are invalid, when they lack any of the major characteristics, you go for letters of administration annexed with a will. Okay? Then, where there is no will, you just go for letters of administration. Where there is a valid will, you go for grant of probate. Okay? But now, the biggest challenge, once you've applied, you've petitioned court, and you know you always have those stubborn sons and daughters who don't agree. So your mom, okay? What is the right of that child? Okay, is to caveat. So that means once you have already started the process, the available remedy will be caveating letters of administration. So you should ask yourself, how do you draft the caveat? Okay, and how do we remove it? That was my question in orals. It was question number 2. My first question was, I give them 5 legal importances of sex backed up with legal provisions. 5 legal importances of sex. Legal with a section now. Because of this section, this is why we do this.
In the case,
Nengezaako nempaayo byempadde nengiseeka wati. Nanga question number 2. Draft a caveat for letters of administration. I swear yanga sinai. Nalemba mu COVID nga sirina kyenjukira yadde. Naye nga mbadde mu practice. Naye nga nkola caveat za land. Ngaawo naasaaga. I drafted a caveat. Nga nkimanyi ya land. I drafted the caveat ya land. Kwa nali njimanyi okufed. Nengi draftinga ne mulaga nti njifayiringa wa mu court. Atunuulira twazina kawungu. Siramu. Tosoboka. Have you been in practice? No, I've been home. Courts have been closed and I can't hold out. Are you sure? Them guys, now question number 3. Ojimazeko. But give the caveat. Them guys, yes. Nali chimanyi kyenkubye kifo naye nga sirina ne bw'oŋŋamba fuluma okumewo oba sirina kyensobola kukola. Ngamba nkuliivu. So what I did, I drafted that. Isn't it a caveat? I had to try just to convince her and what we example max. Nenga yeyo question inakkiriza nti nali wakufuna 0 peacefully. Nali sigimanyi. Okay? But it is even in the act. Nenga no kola by that time. COVID. Yeah. Okay? So that was it. So you have to appreciate. Then after that, once the caveat has been lodged, how is it vacated? And what grounds court basis on to vacate the caveat? Cancel for the week. Get prepared. Okay, that's where you are. Yes. Before, when the facts that you you are going to read the local, so don't worry about that. Okay. So now the presumption is the caveat has been withdrawn and you've been granted letters of administration. However, during the course of administering the estate, because currently the law requires that once you get letters of administration within 6 months, you should file the inventory. Okay? But in the family, well, guy yafuna letters like 33 years, he's 98. Tabawanga koyate. Square miles, guy atambula n'ensawo erimu ebyapa byonna naye tagiteerimu akawuzi wano nawe oyagala nnyo kyokka ayagala banne baffe ababatwale naye yasinza okukaddiwa. Okay, so I told them just take him back to the administrator general, you will see the problem. So n'alwala n'aziba omuntu naye nga mulamu. Okay, so ask yourself, how would you deal with such an administrator? The administrator has not administered the estate within the appropriate time. What do you do? Okay. People with the property are difficult. Okay. Okay. So what happens in such circumstances? You have letters of administration, but the person with the letters are positive. Are done here. Okay, so what you do, you make an application form. Do we revoke? We have the following words. We have revocation, we have alteration, and nullification of letters of administration. That is the hardest provision to interpret in the Succession Act. You should be able to tell under what circumstances do we go for nullification, under what circumstances we go for revocation, and under circumstances we go for variation. Okay, that is the biggest challenge. I think it's going to be the other term, that topic only. That's what you will do. Okay, the other half, that half, yeah? The second half, that's what you're going to do only in the family. Okay, so when you look at that, you should be able to appreciate what is revocation, what is nullification, and what is. So in circumstances where you've read everything and the letters of administration were obtained rightly without any fraud whatsoever. But this person is just becoming stubborn, has failed to administer the estate. Okay, then you go for what we call you are meant. They alter the variable mujeko, but for someone who is competent. If not, they'll give you letters of administration when they have granted to 2 people and one dies. When one dies, remember when a grant is granted to 2 people, for more than one, you can't administer an absentia of the other. So this person died. Okay. So what happens? You go back to court, you are made. They replace that person with someone else. But now they'll give you facts where Jeff applied for letters of administration. Okay. And he lied that his late father left him for 4 children. Yet they had over 60. Okay. So that is fraud. Once it is a fraud, that means it was null and void ab initio. So we go for what we call nullification. We nullify. Okay. Then we want, what about revocation? Okay. Under what circumstances do we revoke? Okay. We have circumstances where on the face of it, the procedure was right. Because these things are in the law. We don't know jurisdictions. Okay? For you, because so you may not be aware that if the estate is beyond 15 M, you go to the high court. So because Jeff is an ordinary person, unknowingly, he applies to the magistrate's court. Okay? And yet the estate is for the high court. And magistrate court grants. So by the time you get to know that, oh, this is a matter of the high court, when letters are out, so we don't nullify. We didn't have the intention to defraud. So we go for revocation. Okay. So, but remember, when you are going for nullification, which example can I use? Have you ever been with something? Ngenda bweru naye nkulekedde emmotoka yange ng'erimu full tank ojja gipanga nkomyewo n'omanya that this person is soon coming back. Oyinayo olaba full tank kanga kotese. I go everywhere I do what? I go before he takes his car. Okay? So this thing happens. Imagine you have letters of administration. You obtain them fraudulently. Okay? And these guys, they want to take them. Okay? They want to take those letters. What do you do? Nange kyenkola nsooka nentunda-tundako. Okay? Ku estate. Not so? Why? Remember, I have the letters. I have the authority to do what? To do sale. Okay? So, but because the law is so fair, they don't want that to happen. So before the letters are, yes or no?
No.
Come and say. Don't work. Yes, we can now and take orders if any. Okay. Huh? Anyone who wants to proceed under St. Thomas Chambers? Yes. Okay. So that's that side. Okay. So because the law knows that people have that tendency, so before you go for nullification or revocation, what they do, we have something known as citation, or some pronounce it as citation, others citation. It is a procedure in revocation. What happens? You first apply to the nearby magistrate's court and they tell him, Mustiram, letter says, Because now once these letters are in possession of court, what are you going to do with them? Before you serve me, so by the time they revoke, at least okay. So, but because court knows that such things may happen, so before you go for revocation, they first say, bring them here. Okay, bring them to avoid such things happening. Okay, so as a result of that, we have succession. So let's get the act now. We are going to just a few provisions and then we go to the workshop. Okay, we have the amendment. Yes, we have the amendment of the Succession Act. Okay, of 2022. It's what we're supposed to use. Okay. Okay. What section was basically amended? Someone interviewed him and advised us in section 27 of the Succession Act because they knew it had an error. Section 27 was on distribution of property. Women were making a lot of noise. They told the guy advised us on section 27. Yatuna butunuziwati nagamba pass. Nanebo mubuza cheki. Ngatamanyi. That is the purpose. Okay, so let's go our acts. Okay. Okay. Okay, let's go to our act. So now, okay, so let's go on. So now, when you are dealing with succession, okay, we have things we first look at. Okay, first ask yourself, when you are dealing with succession, which laws govern succession? You see this act looks a bit big, okay, but not all laws are supposed to be read. That is a very important matter. So the first act we always look at is the Succession Act. Okay, is the Succession Act. Okay, is the Succession Act. Then after the Succession Act, in circumstances where the family had, where no one of the family has applied for letters, who is the first administrator? The administrator. So that means you look at the Administrator General's Act. Okay. Then the Succession Act has no rules. Not so. Okay. It has no rules. But remember, the entity, you're dealing with the process known as administration. So another act is supposed to put, okay, they have given us rules now. Okay, so but the rules don't define how you go to court. You go to the act known as the Administration of Small Estate Special Provisions Act. That act provides how you go to court and how you challenge courts. Of Small Estate Special Provisions Act. Okay. Then after that, you go to its rules. Okay. Then maybe you should also look at the probate resealing rules, where you get letters of administration from courts of other jurisdictions and you want to enforce them here in Uganda. That was last year, but one. That was their question in the final exam. You wanted probate resealing. The rules. Okay. Yes. So now, when you are dealing with succession, first ask yourself, how did this person die? Okay. Did this person die tested or intestate? Okay. So let us first look at the two types of succession. Okay. Over one. Yes. Over one. Eh? Yes. Eh? Kuyinza okuba bwangu ngamba kansona ye. Eh? Nitubeyani tugambye ebirala tuli mu family. Okay. So let's go to section 24. Section 24.
Succession Act.
Yes. Says intestate. Okay. Intestate. Okay. Intestate. Okay. Okay. Intestate. Okay. Okay. It says, when does a person die intestate? It says, a person dies intestate in respect of all property which has not been disposed of by a valid testamentary disposition. You see what the word they have used here? Valid. So where the will is there, but it is invalid, doesn't amount to a will. Yes, Tans. Succession Act. Okay. We are doing the Succession Act. Okay. Section 24. Okay. So a person dies intestate when he or she has not left any testamentary disposition. That's what we call a will. Okay. Never but when this will is invalid, you have died intestate. Okay. Are we together? Okay. Let's proceed. Section 25 says, all property in an intestate estate develops upon a personal representative of the deceased upon trust for those persons entitled to the property under this act. Okay. So now we presume that the client before us is a person who has died intestate. The law says if I die intestate, okay, all my property develops in my legal representative. So the question is, who is a legal representative? Let's go to the interpretation section now. Okay, that is section 2. It says personal representative, that is section 2, paragraph R. Personal representative means a person appointed by law to administer the estate or any part of the estate of a deceased person. Okay, are we together? Section 2, paragraph R. So now, again, when you come back here under section 25, it says, okay, persons entitled to property under this act. You get it? So now ask yourself, which persons are entitled to the property of a person who dies intestate? Okay. How do we call those people? They are called beneficiaries. Okay? So does the act define for us who is a beneficiary, or it does not? Okay? In the act, they don't use the word beneficiary. They use the word dependent relative. Okay? So when you go to section 2G, it defines dependent relatives. Okay? To include a wife, comma, husband, son, daughter, under 18. Yeah. Son or daughter under 18. Now I have a single child. Just. Okay? Say when you around that, that this act doesn't apply. Okay? Okay? So now, under that, they're saying wholly or substantially dependent on that person. We shall identify in our facts, okay, who amounts to a wholly or partially dependent, okay? Okay. Okay, so now we've seen that this person has died intestate. This person has no will whatsoever. So if the person dies intestate, okay, what do you apply for? Letters of administration. So what law gives you how you apply for those letters? What law? You want to apply for letters of what law? Council is saying the Administrator General's Act. Who else is seconding that position? Yes, you go to. Let's go to the administrator. Before you go to that, okay, there is a section that sends you to that. Okay, it is section which sends you to that act. Okay, it's section 91. Okay, let's go to section 235. Okay, section 235 of of the Succession Act. Okay, it says 235 jurisdictions in grant of probate and letters of administration. Okay, it says jurisdictions to grant probate or letters of administration under this act shall be exercised by the High Court and the Magistrates Court in accordance with the Administration of Estates, Small Estates Special Provisions Act. So before you go to that act, you first go to section 230. So then after this, because the Succession Act does not provide for the procedure, how we apply for letters of administration, does not. Okay? Are we together?
Yes.
So then after reading this section, that's when you cross and go to the Administration of Small Estates Special Provisions Act. Okay?
The rules of special provision.
It has the act and the rules, council. Okay? So when you go to that act, okay? Okay? When you go to that act and go to section 3, it says application for grant of probate, etc. Section 3. Okay? It says an application for grant of probate or letters of administration shall be made in the prescribed form and shall contain such matters as may be prescribed. So also section 3 does not give you how you apply for letters of administration. You get it? So now the act has what we call regulations. Then you proceed and go to what we call the Administration of Small Estate Special Provisions Act regulations. Okay. Okay. So now, when you go to the regulations, okay, procedure in contentious, and then it provides how we proceed. Okay. When you go to rule 3 says application for probate or letters of administration. An application for probate shall be in Form 1A of the first schedule of these rules. Okay, rule 3. Okay, rule 3 of the Small Estate Special Provisions regulations. Okay, then rule 3 sub rule 2 says application for letters of administration shall be in Form 1B. So now, you see where we started from? We saw that this person died in the state. Who can apply as the legal representative? Okay. Then after here, we've seen who is entitled to receive. Okay. Then we've seen how the legal representative goes to court under Rule 3, Sub Rule 2. Okay. It is by way of a petition for letters of administration. Now, family, don't draft anything you've gotten around. Diango act. Probate eno petition mweri. Tulo jikube as you will not die. You will not die. Okay. So now we've seen how we apply to court. Not so. It is by way of a petition under Form 1B in the Small Estate Special Provisions regulations. Okay. But now we have things. We've seen the form. So we have two things you need to put into consideration before you apply. Okay? Before you apply. Okay? One, where to apply. Okay? Where to apply. Okay? Where to apply is what we call jurisdictions. Not so, but what factors you look at and determine the jurisdictions? Yes, leave alone the peculiar jurisdictions. Further geographical acting. What factors do you look at? It is known as domicile. That's Freedom Succession Act. That's why I mean a domicile. Okay, domicile. You look at the petition maybe. Okay, so you go back. So the first, now we want to apply, but they are things we are looking at now, so that when we are drafting our petition that we've seen, we know where to take it. Okay, we know who is going to apply and where. But now we first want the where before we go to who, because even the who has a different story. The law has set the priority. Not everyone can come from anywhere and apply. No. Okay? But in practice, it may be different. Eh? So let's come here. What is domicile? What is domicile? Where do you domicile? Okay? So now, how does domicile affect application for letters of administration? Let's go to section 4 of the Succession Act. We've seen that Rule 3 provides that we can proceed by way of a petition. So now, before we start drafting our petition, there are certain things we have to put into consideration so that you draft a petition which is in line. And the first thing we've said, we are looking at jurisdictions, and these jurisdictions we refer to geographical jurisdictions. Okay, and we've said the factor you are looking at basically is domicile. So you've said domicile, this is your place of where you've been staying. Okay, so now we are here under section 4. Okay, section 4 says succession to deceased persons immovable and immovable property. Okay, so what do you have movable or immovable? So what happens, they can give you facts where this person had movable property, movable, had vehicles, had motorcycles, and everything in Kenya. But this person had his house here with land. So you have two types of assets, movable and, but they are in different places. So what determines the jurisdictions? It's what this section talks about. Okay, let's go. Succession in immovable property in Uganda of a person deceased is regulated by the law of Uganda. Wherever the person may have had his or her domicile at the person of his or her death. Okay, listen, succession of immovable property. We want land on site. So the fact one, you see that most of the assets are immovable. Go to domicile. It doesn't matter whether this person has in Ruwero, in Matuga, in Kasangati, in Nakawa. Okay? Because what some lawyers do, they choose any place where the estate is. Okay? But that's why they ask for the LOC letters. You attach them. Why? They want to prove place of domicile. So if the asset you want to administer is not within that place where this person was domiciling, they want to grant you letters of administration. So when you are given facts, first ask yourself, where was this person staying at the time of his or her death? They give you facts that do confuse. They'll tell you that Rashid has 3 wives. Okay, so and so, so and so. He had spent 2 months without going to this home. Okay, 1 month without going to this home. At the time of death, he was with Hajat Muto in Matuga. The section says at the time of his or her death, Nafiri Dewa Matuga. So ask yourself, if the land is in Matuga, where do I apply? That's why you go for jurisdictions. Okay, Matuga, that means I had property there as well. Okay, so Bofira Mudwali, they go with the matrimonial home. Okay, yes, that means you have an option of choosing. See, Islam is good. It doesn't make life hard. Yes, guys. That is his place of residence. Okay. But sometimes you are coming from your matrimonial. Hajati abakulina yafunamu. Yabafunamu. Yakati namba bwe bandewa namba emu. Namba 2 ne namba 3 mwamuwete. Abana amaanyi namba era yabaliko. That is Islam. Okay. Then, if not domicile, but let's proceed and understand this section at once. Then subsection 2, succession of movable property of the person deceased is regulated by the law of the country in which that person had his or her domicile. at the time of his or her death. Okay. However, if it is immovable property, they always give you that I had businesses in Kenya, what and what. So if I have been staying in Kenya, immovable, but you apply to Kenya. Okay. The section says succession of movable property. Okay. That is to say, like cars, what, and a view. Okay. Of immovable property of a person deceased is regulated by the law of the country in which that person had his or her domicile at the time of his or her death. If I've been staying in Kenya, you have to apply in Kenya. In relation to movable properties, you should mark that. Okay? You should mark that. Okay? You choose. At the section at the end, domicile at the time of his or her. If you've been domiciling in Kenya, you apply to Kenya, regardless of the fact you had in Uganda. It doesn't matter. Okay, we apply to Kenya. Then after applying in Kenya, we go for what called probate proceeding. That's how it applies. Okay, we go on. Yes. 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 Yes, the letters will apply. That's why I got to. Okay, we go on. For purposes of subsection 2, a person dying intestate shall be deemed to have his or her domicile in Uganda if. So when you die intestate without a will, we shall presume that you've been staying in Uganda. Over there, we shall presume if the following factors exist. 1, for a period not less than 2 years, okay? For the period not less than 2 years, presiding his or her death. If I've been in Kenya, okay, when I have my properties in Kenya, okay, and when I felt like I'm not doing well, I came back to Uganda. Okay, never sirinamu any movable property. Okay, but by the time I started feeling weak, I came back to Uganda, and I've stayed in Uganda for a period not less than 2. We shall apply here.
And it's subsection 5.
Okay. No, it is still section 4, subsection 3. Then 2. Okay. If he or she was survived by a spouse or a child who was at the time of his or her death ordinarily a resident in Uganda. Never be Kenya. Never Kenya. Okay. When I have movable property in Kenya, okay, and I've been residing in Kenya. However, my legal wife is in Uganda, or my child is a resident in Uganda. The presumption is I have been in Uganda. So we apply where? In Uganda. Even if when I don't have a will here, okay, why? That means all the efforts have been here. Okay, so now, okay, we've seen. So now we are okay with domicile, not so? We are okay with domicile. Okay, then another pertinent thing you have to look at is what we call estate of the deceased. What amounts the estate of the deceased? Bagenda kuba wa facts. The first, your IA is chances are it's going to be an application for letters of administration or probate, but the challenge is going to be on property. They'll give you property like 60 when you have to eliminate, mujja kuba mu partnership, mubere mu company shares, mubere mu yasikira, mubere mu trust, nga actually bw'otuula n'obiyisaamu ng'alina property as deed. Kati gwogeze okube petition, otekemu property, tali property yandi, oba owomi. Tekemu ya Bandareo. Okay, so let's go on, okay? But the judge, you see, they will give you, even these facts, they will give you land, okay? They will give you land, which is joint ownership. They give you tenancy in common. They give you a lease, which has not yet expired. They give you a lease which expired. Everything you've started, they can include it in the property. Because they know you have issues with interpretation of leases. What happens if a lease has expired? The interest is all automatically back. But so this property had been leased, that was some leases. Okay, so what amounts to estate of the deceased? Does the act define estate of the deceased or not? Estate of the deceased. Councillor Jeff, does the act define estate of the deceased? So what amounts to estate of the deceased? Okay, so section 2 defines estate of the deceased. That's the issue. Okay, so what amounts to estate of the deceased? Now, the biggest challenge with the estate, that is the hardest thing to differentiate. Why? We have what we call bequeath. A bequeath. Okay, you have to be able to understand the effect of a bequeath. Okay, in Uganda they say things that have been given out when you are still alive, that bequeath. Okay, mu Luganda ebintu omugenzi byagabe muki mulamu y'omwana wange oyo Vincent mukuwadde muki mulamu. Okay, you get it. Okay, so once this property has been given out, does it still amount to an estate of the deceased? No. And sometimes even in the will, this person mentions that I've given this property to so and so. So the question you have to ask yourself, if this property has been given out, does it still form part of the estate or not? No. So sometimes they will give you a bequeath that has been granted when the law does not allow. Okay, they will give you a will where the guy gave all his property to a church. Oh, other things happen. Okay, does the law allow for you to do that? Okay, under what circumstances can that happen? So if that happens, okay, so for you should be able to read the law and ask yourself, does this really happen? So if you read the law and the people that was done, in the law is null and void, you cite the law that nullifies it, you take it back to the estate of the deceased. Okay, so whenever you're reading facts, sit down and appreciate what amounts to the estate of the deceased. Okay, we have a lot of cases that have defined what amounts to an estate of the deceased. Okay, okay, so estate of a deceased, when you read the law defines estate of the deceased refers to any personal property belonging to the deceased. So the question for determination, what amounts to personal property? Any personal. Okay, any personal property belonging to the deceased. Okay, Okay, that's a case law. Okay, so now, okay, so when you look at that, okay, it is very clear that what amounts to the estate of the deceased is that property that belongs. But now you sit in your small room, you start thinking between lines what amounts to ownership of property. Yonna gye wava buli kye wali osomyeko mu land, sit and revisit. Sit. They will give you property one which is held under a partnership. Okay? Which, okay? They will give you, okay, which is held under a partnership. So is that his personal property or not?
No.
Okay? They give you two, that the guy has a company. Okay? But the company has the following pieces of land. They tell you that he registered the company, even if it is in his name. Now, when you start thinking, is there a difference between the company and the deceased?
Yes.
So that means whatever property he bought from the company doesn't belong to him. Put it aside. The only thing you should go for is what we call the shares in a company, because shares are personal property. But the rest, you keep quiet. Then they give you another piece of land, which is under tenants in common. So ask yourself, what principles apply in tenants in common? Okay. Okay. Obviously, but it can't miss. It can't miss. Okay. So what happens? Okay, in tenancy in common. Okay, how do people own land? How do people own land? Okay. Yes, how do people own land? Okay. It is in shares. So that means Jako share ye ajikolechi ye. You get it. Then you have property in dollar. Join tenancy. Okay. 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 But property in dollar get under joint tenancy. So you know in joint tenancy you have survivorship. So if this person has died, automatically the other person is taking it all. But you know what makes, life is funny. Whatever they give you, why? They at the end, they will give you facts when the family is fighting for that property, so that one of the family members goes and calculates. Okay? These are things that happen in real life. Okay? So then after that, they can give you property he bought and registered in the name of the children. That is not his personal property. Then after, they come to what we call a bequest. They tell you that he gave out this. So your only obligation is to ask yourself, what is a void bequest? So when you look at the fact and it falls under within, which is void, the law has said in full. Cite the law, take it back to the estate. Okay? So let's look at the rest, those things, the rest we can. But when it comes to the bequest, we have to read the act. Okay? We have to read the act. So, first things first, what amounts to bequest? What does the law define it, or it does not? Okay? Does the law define, or it does not? Under the interpretation section, it does not. Okay? So let's go straight forward to the law that provides for it. Okay? First and foremost, what are the different types of bequest? What are the different types you have? Okay? Okay? We have what we call a conditional. This always happens. They can say, emotoka yange gyembadde nvuga girekedde mutabani wange Vincent, naye mujja kugimuwa nga ayise LDC. You get it? Okay? Okay? You get it? Okay. It has a condition on it. Okay. It has, so that means it becomes a valid one upon fulfillment of the condition, and the law allows that. Okay. I'm open supplementary. Okay. So how does the law define? Okay. Yes. So tugambye soka is a conditional. Yes. Okay. So does the law define it? Okay. Does the law define it? Okay. How does the law define conditional? Listen, but you don't want to take it. Eh? We take it back. Okay. So a conditional bequest, this is one that is effective upon fulfillment of a condition. Simple as that. Okay. Effective upon fulfillment of a condition. Okay. Okay. Then another type, we have a contingent. A contingent bequest is under section 111. Conditional is under 113. Okay. But remember, what is it? Impossible conditions. Where someone has given you and has put what the impossible condition, that bequest is invalid. Okay. When the condition is impossible, okay. What if Tata Wachimani oli mugumba n'agamba bajja bikuwa upon giving birth? Abatapuse bose.
Uganda, no.
Okay. Okay. Yes. Why? Okay. Then also another condition that does not is not allowed, an illegal condition. Okay.
Contingent section.
No. Okay. So let's go to contingent in details. Contingent is under section 111. Okay. A contingent. Yes. So now a contingent, okay, is a bequest that is made with uncertainties. Things that where they will happen or unknowns. Kati omuntu bwakugamba nti mumaze oyita backcourse nga naawe tomanyi oba ovaawo watakola ki. Uncertainties. Okay. Okay. So, for example, if someone says that Vincent, I've given him land at LDC, but he will take it upon Robert Chagwan Sentam becomes the president of Uganda.
Is it an impossible? That one is
okay. Okay. We don't know. It is unascertainable. Whatever it is, okay. Okay. Let's get back. Okay. Let's get back. Okay. Let's get back. Okay. We have what we call erroneous bequests. Okay. Section 109. Yes. Contingent to government. Something uncertain. Yes. Okay. So we have what we call section 109. Are we there? Yes.
No.
Okay. Section 109. Okay. What we call, it comes from the word onus. Okay.
Eh?
Onus. Okay. So what happens? This is a type of bequest where you have been given an obligation to fulfill. Government have given Vincent that land, okay, but he should utilize it to pay school fees for the siblings. So I've given him, but with an obligation. Okay. It is
O-N-E-R-O-U-S.
yes. Okay.
Section 109.
It is onerous from obligation. They first give you something to do. Okay. So our great fathers used to do that thing. They say, "Mwala wange omukulu mulekedde enju eyawaka naye alina obuvunaanyizibwa buno buki wammanga." Okay. So that obligation, so that bequest falls under this. So when you are given a will and you see all of these, okay, so all those are valid. So once the deceased has given out any of his or her properties in those circumstances we've mentioned, it is valid. So that property no longer forms part of his or her. Now we have what we call void, when the law doesn't allow such bequests. Let's go to section 99. 99. Okay. So when you read that, it provides for different circumstances. When you one time I was listening, I always listen to Adam Huxley. Okay, for certain reasons. Okay, they educate you. I was listening to Paulo Cafelo's song of okay, of Walum Messiah. He said, "Mubyokusaga nali samu kiramu kyokusika n'akolaki n'akusookayo." What does that mean? In your will, okay, you bequeath certain property to your proposed heir, not so, and the heir dies first. So when you don't amend that will, okay, and that will comes, okay, and the person you gave is not in existence, so that bequest is void. So that property, we shall take it back to the government of the family. Yes, ma'am. Okay. Yes.
I'm not my estate, but I'm not people I want to benefit from. They died before. For example, I'm a mama, and then my kid dies before, and I take my daughter. Then the daughter will go to the right children. Am I making sense?
Yes.
What happens to that scenario? Because very soon, we're making use of 21 to benefit the next generation.
Okay. You do what we call a codicil. Upon death, you make an addition. You make a codicil. You make a supplementary will. You can. We have what we call direct beneficiaries and subsequent beneficiaries. So you fall under what we call subsequent beneficiaries. Okay, you can. Okay, so so now let's look at this. So whenever you see these that are void, the Lord doesn't allow them. So once you see that it is there in the fact, take that property back to the estate. Section 99 says, where a bequest is made to a person by a particular description and there is no person in existence at the testator's death who answers the description. Okay? No gamba, not either widayo mwana neo tyo mwogera. No gamba ettaka lyange ery'ennatete liwadde mutabani wange mweru yeru si mweru nnyo. You get it? Otyo mwogera. So mukufa ne basoma description y'omuntu oyo n'atajja kitegeeza takola ki? Wallahi ninawe nagenda okuziika nasirikirira bwezi ne ngamba abasajja bazira. The guy had 4 children at home. Four. Naye nga alina best friend we gwatambudde naye for 25 years. Guy yali yayita kanso naye nga yono smart person abeera nnyo ne bakanso. Yali akola awo wansi ku ng'ate ng'alina ka office ku NASA. Okay. So listen. Listen. Okay. So so we went for the burial, but on the day of the burial, 15 children appeared. The guy even had a doctor, but the best friends knew each and every child in a jar in a mama way. So the guy came to speak and you know we use a what kiwomkuru but jagalambuweyo. The guy started looking around. So he made a call. That woman his favorite child. Ngatamanyi najiba muzaala yadde ki. Naye ng'omwana abadde akimanyi taatawe mulwadde naye nga yamulaba. N'agamba Peter jangu uyazze ng'ava ku boda. N'atya nga imirira wano namwandu n'atunula ne ngamba wano nno. Babagidde ku sayidi y'omwami bagenda tukuba emiggo. N'atandika Dokasi tasobodde kujja ali mu America asoma busawo. Naye ng'abaana basomera ku kyalo abawaka wano. Peter taliiwo ali ku mulimu e Bungereza naye akimanyiiko. N'agamba mpozi waliwo omwana gwe mubadde mutera okulaba ewaka wano. Omwana oyo twamuzaala mu Jane. Nze bantuma wawe twagendanga mu myaka gye. Naye ng'omukyalo omwana abadde amumanyi nga na mukwano gwe naye nga tamanyi nti mwana wa mukulu. So the guy named a list bonna ne bavayo ne bayimirira awo. So the widow was like now bano bonna baana baffe naye ng'abadde ayinaaba ng'omukyala bamanyi. The guy nga tasulako bweru. Okay, so in such circumstances, okay, let's get back, okay. Okay, members, let's get back. Okay, so in such circumstances where this guy feared to air out the children, and this person just gives a description. So if Omanu Waba does say, the presumption is that bequest is not there, so let that property go back. Okay, then the section says, and okay, then the bequest is void except if the property bequeathed to the person described as standing in the particular degree of kindred to the specified individual, but his or her possession of it is deferred until a time later than the death of the testator by reason of prior bequest or otherwise. So they leave it there until sometime to ascertain. Okay, but in the first thing is it is void. So they'll give you facts where Vincent anticipated that he has a pregnant someone somewhere. Okay, so then he made that. After making it, and upon his death, The closest friend analyze that. Yori amulimba. Okay, so that bequest is null and void. So that property goes back to his estate. Okay. Then section 100 provides for another void bequest. It says a bequest to a person not in existence at the testator's death to the prior bequest. Okay. Of course, then you want by the time you die, so either this person died before you or okay. You know these people who anticipated na Harriet agenda kunzalira notandika okukola ekiramu n'omwana n'omuteekamu agwata n'akufuna amuloga. Okay, so then section 101 rules against perpetuity. No bequest is void by which the vesting of the thing bequeathed may be delayed beyond the lifetime of one or more person living at the testator's decease and the minority of some person who is in existence at the expiration of that period and whom, if he or she attains full age. Okay, so that bequest is valid. Okay, so that means they have to wait until this kid attains the majority age. Maybe okay, now the biggest problem is 105. Bequest to religious or charitable cause. Mugabira Chachi, Emizikiti, okay, and all such other entities. Okay. Okay. It's 105. Okay. 105. Okay. 105. So let's read it. It says, listen, no person having a nephew or a niece or any nearer relative shall have power to bequeath any property to a religious or charitable use except by a will executed not less than 12 months before his or her death and disposed within 6 months from its execution in some place provided by the law for safe custody of the wills or living persons. Okay, what does this section mean? Omuntu yenna alina kizibwe. Okay, okay, any person with a nephew or a niece or any immediate relative, the law doesn't allow you to bequeath property to a church or any charitable organization or a mosque. The law doesn't allow. Abana bonna banyiza biwadde kanisa kamuzeeya k'ekikyamu. Okay, so the law has said it is invalid, but it can be valid on the following conditions. One, that it is in the will, and the will was made, okay, 12 months before. Okay. Why? 12 months before you die. Kiwakikola omwaka gumu ki lwaki abanaddiini bano bwe bajja mu ddwaliro tulaba. The reason when they can okay, zeri katonda omwoyo gwo okay, so that what is changes your mind. So they don't allow that. Okay, okay. Baba omusumba ng'agamba abantu mu COVID mutereke ekimu ekyemmeka. Okay. So are we together? Okay. So now, if not, okay, if not, after the will has been made, it was kept in a place mentioned under the law for safe custody.
Number two.
The conditions are zero. Okay.
If
one, ochikoze a year before you die. Then two, you kept that will in a place that where the law allows it to be kept for safe custody.
kept that will.
Okay. So they will give you facts. When this guy made a will, 7 months, and that will has given the church property. Okay. So that will is void. So that means that property should go back to the estate of the deceased. Okay. So what places? Okay. What places? Where do we keep the will? We have the lawyer, okay. Then we have the code, not bank. There is a name they call that box.
Post office.
Okay, it's a safe deposit box. Okay. Then 3,
Safe.
okay, safe deposit boxes. Okay. Then 3, religious leaders. The law allows. Okay. Then we have another one.
Here's a C1.
Okay. Trusted individual. Okay. Okay. So now, so now when the facts are given to you, what doesn't belong to this person? Okay. Then also property, the property this person inherited. This person is just a legal representative. Okay. Where you are an administrator of a certain estate, that's not your estate. Okay. They don't allow that. It's not yours. You are just a trust. So just take your portion as a beneficiary. Okay. Yes.
Most of the time, the administrators of estates of the deceased, they are beneficiaries of that estate.
They have their portion, not that all the entire estate belongs to them. Yes. If not, now they'll give you land which is owned customarily. You get it? That his father inherited from his father, he also inherited from his. That is customary land. It has no pass. You get it? So that means it has to pass to another generation. Yeah. Okay. So ne bw'aba agitaddemu gwe lawyer agenda okusoma facts gijjeemu. Don't make that mistake. It's like this. Olina ayina okuddira mu bigere under customs. You know how customs work. Okay. The customs. I know what I mean. Customary land. Okay. Customer. Okay.
I'm here connecting that.
We speak
Customary land. Okay. No, let's listen. Okay. Customary land. Okay. Sometimes some customary land doesn't belong to you as an individual. It is for entire clan. So when you are the clan head and you die, you become the successor of your father. So that means that estate comes to you. When you die, another person, so it's not your personal property. So you should be able to differentiate. Okay? Yes. So now, after you've looked at the property, Then another thing we look at are beneficiaries.
Eh?
Beneficiaries.
Cancel.
Okay? We've looked at the properties.
I think, wait.
Be prescribed like Simulacro. Okay? So now we want to look at the beneficiaries. Who can benefit? Okay? Who can benefit? Okay? Who can benefit from the estate? So they say dependent relatives. So the question for determination, who amounts to a dependent relative?
Girlfriend.
Okay? So when you look at the law, it says wife. Okay? Wife. But in the amendment, they say wives. You get it?
They were right.
You get it? Before the amendment, it had wife. So in the amendment, they said, and even they went ahead to define first wife. You get it? In the amendment. Abgemaniga first wife. Okay? So, whenever you are not legally married, okay? Then if I die, stop sigari yo. You know our Basu they said that
Equity.
yes, okay. No. So the first one we have is wife. Who amounts to a wife? Someone who is legally married. So if you are not married, then the second dependent relative is your husband.
Have a second.
Okay. With the way the law mentions husband. Okay. Husband. So even if you die, your best husband can benefit from your estate, provided that you guys are married. Remember, husband, we don't have first, second.
We have one.
We have only one.
I can have.
Okay? You have only one. Okay? Then, okay? Then, after husband, we have mother and father.
My parents.
Yes.
For the man, not for the
Okay? Mother, father. Okay? Then we have children. Now, the issue of children, we have legitimate and illegitimate, and then adopted children. When it comes to children, we have legitimate, illegitimate, and adopted children. Okay? So, when you're not legally married and you have children, so if you are not married and you have children, the share they get, it's what you get on. Under the law, when you are not married, we don't know you. We don't know you. You're just a friend.
Just a friend.
Okay? You're just a friend. So they'll just apply it. If the family of the deceased deems it fit, they'll give you one boy spotter, one single room. You go with that. So you guys get married, yeah? It is nice.
No, we just have to work. We don't have to get married.
No. Okay, so then, okay, let's go on. Then after that category, members, listen. After that category, we have what we call other dependent relatives. The people that have been solely depending on you. Okay, these people, I'm paying for so and so fees. I'm paying for so and so. My grandmother is sick. Okay, all those are what we call other dependent relatives. Whether solely or partially, provided you've been taking care of them, they should benefit as well. Yes, ma'am.
So there are things like they come, start staying at your place, God, because maybe you don't have their time. They say that maybe, yeah, so even you, Definition of an definition. Let us start African
Okay, so let's get back. Okay, let's get back. Okay, so now once you realize all of that, you can proceed and draft your petition peacefully. Okay, no, remember, we have what we call implied. If these guys came and they have been depending on what you've been giving them at home, they are dependent. They are dependents from you. So they should. Okay. You include in the will. Even in the petition, you include them. Okay. So now let's get back. Okay. Let's get back. So you see how we've moved. At the end of the day, even we entered into tested succession. We've been talking about the will, but there is something we've left out. Regardless of that, we talked about the will. We've left out something. Okay. We've left out something on the will. Contents of the will from the law. How we write the will. From the law says construction of. How do we construct a will, Hajat? Do you have one? Okay. Some people think that okay. How do we construct a will? Okay. How do we construct a will? Yes. How do you construct a will?
And according to the law.
So now, remember we said we have two types of wills, okay? We said we have privileged and unprivileged wills, okay? The unprivileged wills are the disorderly wills because the law thinks we are not privileged, but they should revisit that law. Soldiers are unprivileged people. Sorry for interruption. Okay. I amend my earlier statement. They are privileged. Okay. Okay. So when you look at section 50, okay. Okay. Section 50 says execution of unprivileged wills. Our ordinary wills. So when you look at that, first ask yourself, who can make a will? Okay. Not everyone has capacity to make a will. Okay. Not everyone has capacity to make a will. Okay. It says, except as provided by this act or other law, for the time being in force, every testator not being a member of the armed forces, employed in an expedition, or engaged in actual warfare, a mariner at sea must execute his or her will according to the following provisions. So what does that mean? Whenever the things mentioned here in are not on that will, it is not a valid will. Okay, so section 50 provides what we call validity of a will. When you see this, that means that if you see when these things are not there, that person died intestate. Okay, provided it doesn't qualify to section 50. Simple as that. And we already discussed section 50. Okay, because they say one, the testator shall sign. That's the signature we talked about. But when you are discussing the issue of a signature, don't forget the case of Frederick versus Orient should be in Latin character. Then B, the signature or mark of the testator or signature of a person signing of him or her shall be placed there to appear as intended thereby. It should be in a visible place. That's why we're signing our guru, wano over wansi. Okay. They don't sign at the extreme end. You may mix the signature with the words. Sign up or here and outside the margin or below. Okay? Then it shall be attested by 2 or more witnesses. So if it is not witnessed, woman. Okay? No, not all sections were amended. Okay? Okay? So now, the presumption is we have a will, we have everything. Okay? Now we want to know who qualifies to apply for letters of administration or grant of probate. They will give you facts when your client can't apply. Okay? So we have a section which talks about priority in applying for letters of administration. Priority. Who has the first priority? That's the question. Okay? This law. Priority in applying for letters of administration.
That is section 108.
Okay, no.
Section 50 was amended.
Section 50. So you look at section 31 of the amendment as well. Okay. Yes. Section 31. Okay. Then, if you want to understand where the will is supposed to be kept, you look at what we call the Succession Act Safe Custody of Wills rules. It tells you where the will should be kept. Okay. The Succession Safe Custody of Wills rules. Okay. It tells you where you should keep your will, even in court. But the court, you keep it only where? In the High Court, not in any other. Okay. So let's go for priority in applying. Okay. Yeah, no, because sometimes people have to, okay, they can keep in court, but they provide for the procedure how you keep your will in court. You first apply, it's not automatic. Okay. You never judge your guess. It is the succession wills custody, safe custody of wills. So let's go to the administration of estate, small estate special provisions, probate and administration rules. Okay. You look at Rule 10 and 11. Where we have a will, who should apply? Okay. Where we don't have a will, who should apply? Okay. Where we have a will, who should apply? And where we don't have a will,
which law is this?
okay. The rules, the small estate rules. Yes. Yes. We've said we look at the succession safe custody rules they provide. Just only 3 rules. Okay. So are we there on Rule 10 and 11? Okay. Rule 10 says. Rule 10 says. Order of priority where the deceased left a will. Order of priority where the deceased left a will. It says a person entitled to a grant of probate or administration with the will annexed shall be determined in accordance with the following order. A, the executor. So where there is an executor in the will, that person has the first priority. Then any residual legatee or devicee holding in trust for any other person. Where the testator left a will, but didn't mention the executor. But this person has a trust. So that person who is the legatee, whom has been given a legacy. Okay, that person. He said that upon death, you've not mentioned this person directly, but you've given this person some responsibility. So that person can also apply. That's in case you have a will. So when you don't have a will, who has the right to apply? Okay. Then let's go to 11. The persons entitled to grant of letters of administration shall be determined in accordance with the following order of priority. A. Children of the deceased. Children.
Excuse me, Counsel.
Yes, Counsel.
I would like to have a recap on the rules that we are getting from.
Okay, we are provided for under the administration of estates, small estate, special provisions rules. Okay.
Not action.
Okay. So are we there? So now they will give you facts.
Thank you.
Okay. Why? The first son or the first daughter is not a legitimate child in the Gambo saga. Okay. Okay, you get it. So after the children, who else? Okay, the surviving spouse. You see, so mom or dad doesn't come first. Children come first. In case we don't have a will, children are the first priority. Okay, children are the first priority. Okay, so they'll give you facts where this person had a son, but upon demise of the mother, the father applied. Okay, the father applied without knowledge of the children. So that means he obtained that fraudulently. Okay, yes. Now, okay, the only challenge we have, the exception to this, where there is a contention in the children, okay, two, where the surviving children, the first one does not have the majority age. So there, the spouse even applies without certificate of no objection. So the only challenge is where the priority is given to the spouse, we don't go for a certificate of no objection. That's the only relief. If it is the spouse applying, they win. We don't go to the administrator general. But if it is the child, we go to the administrator general for a certificate of no objection. Okay, we shall get there. Okay, then if not, we go to the father or mother of the deceased. Okay, the third one, the third category, father or mother of the deceased. Okay.
The second one is what?
The rules. Okay. Then we have the father and mother of the deceased, then brothers and sisters of the whole blood. Okay, the fourth category, brother and sister of the whole blood. See, half blood. Okay, not half blood. Okay. Okay. Then when you look at it says the issue of such child of the deceased, except that a person entitled to grant of letters of administration under paragraphs 2D of this agreement may, without consent of persons entitled in the same degree in writing, authorize any person entitled in the next degree under this paragraph to apply for the grant. Okay, you get it. If that's why when you go to the Administrator General's office, the family gives consent because of this section. You give the family consent. Okay, you choose someone you want, then that person will apply. Okay, so now let's do something from the workshop, I guess. Okay, let's read something on the workshop and list workshop 1. Yes, yes. Now, all the provisions of the Small Estates Act, they apply. Look at section. Which section? The section we read that said us to these rules in the Succession Act. 235. It says the small estate rules apply. Whether it is so, it doesn't matter. Okay, does not matter. So let's get the workshop. We got this workshop 1, and we go out. Okay. Yes, outside. So let's look at the learning outcomes first. Okay. Okay. So when you look at the learning aims of the entire workshop 1 and 2, it says 1, to explain the distinction between tested and untested. That one we okay. Then 2, determine who is suitable or eligible to apply for probate stock letters of administration. Okay. Then 3, appreciate the powers and duties of executors and administrators. Okay. Appreciate the role and powers of the Administrator General. Demonstrate the procedure of obtaining probate or letters of administration. Demonstrate the procedure of resealing. Okay. Then appreciate the law and procedure on challenging a petition for probate. That is the mood. Simple. Okay. So let's go to the facts of workshop 1. Okay. Okay. Now you see what makes this workshop huge? Property. That's what I told you. They give you a lot, but when a few qualify, that's the challenge. Okay. So we are saying that my name is Chiwede. Have been suffering from diabetes for over 25 years now. Okay. I am afraid. Okay. It says, I am afraid and very anxious that I'll die very soon. So from when you read that statement, has this person died?
Not yet.
That means we are not going for succession. We are going to make a will for him. Tanafa, characteristics of a valid, it is ambulatory in nature, takes effect upon. So what does that mean? That takes us to the hadith of the Prophet sallallahu alaihi wasallam. Use the power of your left hand before you. Okay. Then we say, all my internal organs have deteriorated because of drugs I take. I have also suffered from mental illness since my childhood. I became mentally ill whenever the moon appears and whenever I get very emotional. My personal psychiatrist is Dr. Mary Z. Buenje. Okay. I have many children and wives. I married each of them under custom. My wish is that there should be no strife in my family when I die. Okay. What does that mean? He wants to distribute his estate before he dies. So you have to advise him. Okay. So we don't want to look into the children. Okay. So they're all dead. But the biggest contention I want is basically the farm, the property. That's what I want to distinguish for you. So when it comes to estate of the deceased, it includes both movable and immovable property. Okay. So if it includes both movable and immovable property, ask yourself, does this property belong to him or? We start. Property 1, 20, that one is his. Then 30 goats, it's his. A modern farm in Muvende, his. 30 acres, his. 10 acres, his. 4-bedroom house in which I live with my wife. Huh?
The meat processing plant.
Mm-hmm.
Is that a company or?
Okay. No, it's just a farm. They have not told you. Okay, just take it the way it is. Okay. Then a 4-bedroom house in which I live with my wife Santa, Leka, and her children. I want you to put a star on that. That is a matrimonial. Do we distribute it? We don't. Go to section 27 of the amendment. Matrimonial property is not distributable.
Section?
Okay. Section 27. Then, yes. Then a bus which Paris Kampala Muvende, that is his. Okay. 3 motorcycles, his. 3 commuter taxis, each of which is managed by my son Biansi Chintu Musisi, his. Man at the bank, his. Then 50 shares in Danzel Construction. So the shares are his.
Yes.
Okay. Then 4 acres of land, okay, at Singo, where my forefathers and my father were married. Okay. Listen, I too will be buried there. I am the heir of my father. This land is registered in the name of Chiwede Francis, my name, Chiwede Francis, that and that, as an administrator. Is that his property? You cancel that out. Okay? Then I inherited this land from my father. My father inherited it from the grandfather. That one doesn't belong to him. A plot of land at Impinda, Kampala, that measuring approximately 200 by 200, housing finance bank registered a mortgage on this land. Okay, I am due to complete the payment of the loan in December. Now, when you look at this thing has two. It has two. It has what we call debts. You get it? We have debts and credits in estate. So this debt, it is a debt, but they have not given you the money. Okay? But you have to put a star. But the property is his because he has the legal interest. A mortgage is an equitable interest. So the property remains his. But what does that mean? His estate is subject to payment of this debt. Okay, that's why I've given you that. In case he dies before December, these guys have to pay the bank. Okay. Then 1 acre of land at Namugongo, that registered in my name. Okay. 20 acres of land at Ruelu, registered in the names of Chiwede and Santa. Okay. Is that joint ownership?
Yes.
What law applies there? So you see here. Okay. A residential house at Sunday. That, okay, registered in my name. It's his. Land at Intinda Chivuga, that with block residential apartments, monthly rental income. This property is approximately 90 million shillings. It's his. A farm, okay. A farm on 20-acre piece of land at Sisibuikwe in my name. I gave this land to Alice Musime, a woman I came with when I returned to Uganda after working for a while in Nyamitanga, Mbarara district. She is very enterprising. Alice Musime and I were blessed with twins. Is that property his? Okay. We don't care. This is a bequest that he gave out willingly. It doesn't belong to him. Okay. I live with my mother and maternal auntie, both of whom are also diabetic. I have looked after them fully for the last 20 years. I also look after my brother's son, Nicholas Mikisa, whose father, Gerald, passed on. Those are what we call dependent relatives. Okay? When Nicholas Mikisa was only 10 years old, I have fully maintained Nicholas since then. He is now a student at medicine. I built a house for each of my wives and each of them. Okay, what does that mean? Each wife, they have their residential. However, when you look at who amounts to a dependent relative, so they have also a share. Read section 27. What a wife should get, a legal heir, children, and the rest. Okay. You are the legal assistant of MS Omoni and Company Advocates, Plod that Kampala. Mr. Omoni instructed you to interview Mr. Chiwede. You interviewed him and recorded an interview statement. They have asked you to do the following. 1, advise him on what constitutes his estate. What additional information you would require from Chiwede in order to prepare him a valid will. You need witnesses. You need where he will keep it. Okay. Then after that, has he given you where he built for his wives? Okay. Then also you need names of his wives. Then also you need the, okay, all the other side. Yeah? Then you have to show their age of each and every person. Okay, you should have that age. Okay, you should have age. Then also, Okay, names of any other relatives. Then also, he should tell you where he built these houses for all his wives. Okay. Okay. Then also the intended executors. Okay. Yes. I do. I first do what? I go to from the beginning. Yeah?
Of the workshop.
No. We've said one, we need to know the age of all the relatives he has given us. Then two, the witnesses he wishes to have. Then three, where to keep the will. Then four, I go see myself. Fireworks. Yes, that's all the man. So where are they?
One border.
Okay. Okay. Then the executors who will execute his will. Then, okay. Then also, did he tell you where he's residing currently? You need to know that place. Okay.
I will say.
Mutia fireworks later, mutia percent.
It was a jack for mine.
Now what is the nature? Wanga twajiro uzo wa board
Hello, byaganye.
was a film. But that was the past to consult. Now, you used to have a prepare. Come there, when it's a as in if I make
You got them make to go in the cheap. So this way those are like 50%, but it's
85% of
oh, you know, so much. I attend classes. I attend classes. I made minutes. Yes, I'm going to forget. Weekend. Control society.
There's a video one. What's it date? Simple date.
Okay, so proceed. Yes, we are safe. Okay, so then assuming that you obtain the relevant information, draft the will. So that means you look at section 50 and its amendment. You make him a valid will. Okay, section 50 and its amendment. Okay, then after making a will, they say, assume that Mr. Chirede died. Then you go for what we call obtaining of letters of probate. Then you draft. Okay, so you're going for what we call obtaining letters of probate. So then when it comes to the steps, that's very simple. Okay, notification of death. Okay, obtaining a short death certificate and a long death certificate. Okay. Okay. The steps are: 1, notification of death. You get that notice of death from the hospital. Then you go to the Gomborola. You get a short death certificate. Okay, but how do you get it? You go with an introductory letter from the LOC, then they get you a short certificate. Then after, you go to NIRA, you get what we call the long death certificate. Then after that, you collect all the will and any relevant copies thereof. Then you also obtain all documents relating to the property mentioned there in the will. Then after, you draft the petition. After drafting the petition, you pay the necessary fees, 6,000. Then after, you lodge your petition, okay? And then after lodging the petition, they will sign the notice for you, to whom it may concern. Then after signing the notice, you take it for advertisement. Then after advertising, you return back proof of advertisement together with copies of identification forms. These identification forms, they include 1, this girl was here.
Yeah?
This girl was moved out here. Abadde awo kudagamba omuntu kati akalogo babyawo just ng'afuluma.
Yesterday they saw my friends who were moving. They just
Yeah.
got some food. Ate bwe batwala kaasi ogendera mu mpejja.
Yes. Okay. Let's get back. Okay. That's life.
Anti era
Those guys come with it.
ate bwe
Their bikes zibasiduka. Now you see this girl abadde wano. Yali yakawuddwa nnyo tuition awo ng'amutadde mu nsawo 3M. Asala bw'ati ezayo disi. Ona abadde wano. Yava wali ku mobile money. Okay? Kati ng'ayagala kusasula. Nga ka system kali off. Okay? Zali sawa nga 2. Asala bw'ati afune boda asula wali ku nana. Asala bw'ati owapola yamusimirako n'amukanga bw'ati n'atwalirawo. Kigali amanya alina ssente nga tayinza kulisinga kola ki kati ng'ayagala asala dde wano. owa boda yamukanga bwati namusibirako piki ensawo ne bagitwala yatunda kutuuza okoleki.
Abasajja bamubba muleke.
It was around 8.
Stop your hand. They have sharp knives.
Yeah.
I wanted to show you a copy of that.
That place is very bad. Okay, so now after that, okay, then workshop 1 will be yes, okay, film identification. We've said the identification currently you take the applicant, the petitioner independently, and then even the persons who witnessed the will, every person should be identified. Okay, so that means yes, obtaining probate now. Even the person who is in the witness of the will should be identified. Today I have a colleague, Bamugovie, marking identification, witness somewhere yaganya okuja witnessing a will. Bamugovie. Imagine what that's the law currently, because things concerning it, people have taken property of people than how you think. Okay, yes. So then after that, they want you to draft the documents. That is the petition for probate. Okay, the petition for probate and its accompanying documents. Simple as that. Okay?
Ethical issues.
Ethical issues, reserve the job.
Don't overcharge.
Disclosing
Cheap parts.
all the, but you say get money. The only money you include in this process, because the challenge is on the advert, now you attach a photograph of the deceased and the applicant. So when they are charging for the advert, it's around 180. Then the 60,000, how much is that? But you enter into an agreement, letters of administration. Lawyers will never see heaven. Those who don't ask for that, they say, you can give me 10 million. Kanso sizina wetano. Nenga kutano gena kosake mitwala.
It's a transport.
I transport ozo. Buli kimu okikolera. So let's bring this and but colleagues, okay, before we leave, okay, yes, yeah, before we leave, okay, before we leave,